We need to talk about a major legal fight now sitting on the Supreme Court's docket, one that could directly affect every American gun owner's rights inside their own home. This isn't some minor procedural dispute. This case could redefine the limits of when law enforcement can cross your threshold without a judge's signature. And, just like the landmark decision in Caniglia v. Strom, this one has the potential to strengthen the Fourth Amendment protections against warrantless entry and gun confiscation. The case is formally titled Case v. Montana, and it's built on the foundation of a previous Supreme Court ruling that came down in a unanimous 9-0 decision. That earlier case, Caniglia v. Strom, was authored by Justice Clarence Thomas and made it crystal clear the so-called community caretaking exception, which allows warrantless searches in certain circumstances, does not apply to private residences. In that situation, police seized Mr. Caniglia's firearms without a warrant, and the court ruled that was a violation of his constitutional rights. Now, Case v. Montana is taking the argument further, asking the court to decide just how far law enforcement can go when they claim an emergency exists. Gun owners should be paying very close attention, because the stakes aren't just about privacy, they're about whether police can bypass the warrant requirement, enter your home, and potentially take your firearms without the due process our Constitution demands. Here's how this all began. Trevor Case's ex-girlfriend called local police, telling them he had made statements suggesting self-harm and that he might have a firearm. Officers responded, parked outside his home for roughly 40 minutes, and eventually decided to go in, stating they believed there was an urgent threat to his safety. Once inside, things escalated quickly. One officer later claimed he saw a shadow and believed Mr. Case was reaching for something, possibly a gun. The officer fired, hitting Mr. Case. After the shooting, police searched the home without a warrant and discovered a firearm hidden inside a laundry hamper. Prosecutors later charged Mr. Case with assaulting an officer during that chaotic encounter, and he was convicted. The facts here are messy. No one is denying that. But history has shown us that the Supreme Court has delivered strong pro-rights rulings even when the underlying incidents were far from perfect test cases. What matters is the legal principle. If the court sides with Mr. Case, it could slam the door on more loopholes that allow officers to bypass the Fourth Amendment under the guise of emergency response. This is one of those rare situations where the outcome will set a nationwide precedent. And it's not just academic, it could determine whether your rifles, your handguns, and yes, even your trusty .22 long rifle plinker can be taken from your home without a judge ever signing off. Trevor Case has argued from day one that the officer's warrantless entry into his home was a flat-out violation of the Fourth Amendment, and that any firearm or other evidence found as a result should never have been allowed in court. The lower courts didn't buy that argument, but the case kept moving upward until it landed before the Montana Supreme Court. In a razor-thin 4-3 decision, the Montana Supreme Court sided with law enforcement. Their ruling adopted a test that says police only need an objectively reasonable belief that an emergency exists before stepping in without a warrant to help someone. That's a far lower bar than the traditional requirement of probable cause, something at the heart of the current dispute. Mr. Case and his attorneys are pushing for a tougher, higher standard. They maintain that the officers had no genuine exigent circumstances and that the federal emergency aid exception simply didn't apply in this scenario. A key point in their argument is the 40-minute delay before officers made entry. In their view, that waiting period is proof there was no ongoing crisis requiring immediate action. They also reject any claim that this was valid under the so-called community caretaking doctrine, a legal theory the Supreme Court already dismantled in its unanimous 9-0 ruling in Caniglia v. Strum. Montana, on the other hand, is saying that their objectively reasonable basis test is basically the same thing as probable cause in real-world practice, and that this fight is more about word choice than actual constitutional substance. One of the biggest anchors in Mr. Case's appeal is Caniglia v. Strum itself. His lawyers are arguing that this is a perfect opportunity for the Supreme Court to clear up exactly how the exigent circumstances rule should work when police claim they are providing emergency aid. Since Caniglia was decided, many lower courts have been all over the map, often defaulting to an exigent circumstances approach instead of sticking to the tighter limits that rulings seem to require. If you're not familiar with Caniglia, here's the quick backstory. During an argument with his wife, Edward Caniglia placed a handgun on the table and told her, "Just shoot me and get it over with." His wife left for the night, and when she couldn't reach him the next morning, she called police. Officers found him on his front porch and eventually convinced him to go for a psychiatric evaluation. Mr. Caniglia specifically told them he did not want his firearms taken, and the officers agreed to leave them alone. But that agreement didn't hold. After he was transported, the officers told his wife falsely that he had given them permission to seize his guns. Believing that, she let them inside, where they collected 2 handguns. The Supreme Court later ruled that this community caretaking excuse did not extend to the home, making it a key win for gun owners and privacy rights. That dispute in Caniglia v. Strum ultimately made its way to the United States Supreme Court in the year 2021. In a rare and powerful show of agreement, all 9 justices sided with Mr. Caniglia. Justice Clarence Thomas authored the majority opinion, grounding it firmly in the Fourth Amendment's guarantee that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. He emphasized that the very heart of that promise is a person's ability to retreat into their own home and remain free from unwarranted government intrusion. Justice Thomas went further to note that what may be considered reasonable in the context of vehicles is not automatically reasonable when dealing with a person's home. On that basis, the court struck down the community caretaking rationale in the home setting, issuing its unanimous decision in Mr. Caniglia's favor. Since that ruling, the Supreme Court has not taken another direct look at the limits on warrantless home entry until now. This new case out of Montana offers the justices an opportunity to revisit and potentially expand upon the principles laid out in Caniglia. The court has agreed to hear it, which means both sides will be submitting additional written arguments for the upcoming term. Sometime before the term wraps up, the justices will hold oral arguments and then issue a ruling. The stakes are high. While this is not strictly a Second Amendment fight, it goes straight to the core of our fundamental rights, specifically the boundaries of government authority and the limits of so-called exceptions to the warrant requirement. The outcome could redefine the protections all Americans have when it comes to the privacy and security of their homes. We will be tracking every development. As more details come in, I will keep you updated. If you enjoyed this breakdown and want to help the channel grow, one of the best ways is simply to subscribe. You can also grab my free legal guide through the link below. And as always, thank you for your continued support. Never forget this nation was built by armed scholars, and it will be preserved by armed scholars.